persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Please be seated. Good morning and welcome to an oral argument session of the 5th District Court of Appeals. I'm joined on the panel this morning by Judge Vincent Torpy on my right and Judge Carrie Evander on my left. We have 4 cases this morning, 1 criminal and 3 civil. So the criminal case has 15 minutes, and of course the appellant can reserve some time if he or she chooses to. If you have a cell phone, we'd appreciate it if you would silence it so that the parties are not interrupted during their arguments. And with that, we'll go ahead and start. Call the first case, Joe Rogers versus State of Florida. Morning, counsel.
Good morning, Your Honor. Good morning. May it please the court, my name is Josh Moore from Carlton Fields. I'm appearing on behalf of the appellant Joe Edwin Rogers, Jr. At this time, I would like to reserve 5 minutes for rebuttal, please.
All right, sir.
Thank you, Your Honor. This appeal arises out of Rogers' conviction for child pornography, for possession of child pornography, which must be reversed because the state presented no evidence of knowing possession. Now, the applicable statute requires proof that the defendant knowingly possessed a photograph, image, etc. He or she knows to depict sexual conduct by a child. In this case, the state had the obligation to prove that element and did not. There was no evidence that Rogers knew there was child pornography on a computer or in any form, that he transferred...
Well, there's some evidence that his wife, ex-wife, whatever, had brought it to his attention that he had these images on the CD.
Your Honor, the evidence, I believe, is that if you read the wire transcript, which is where that evidence came in, Mr. Rogers says his wife said you need to get these pictures off of the computer. The discussion between Schlegel, who is his girlfriend at the time, or ex-girlfriend at the time, she's the one who brought these.
Girlfriend, right. Okay.
She brought these to the attention of the police. The discussion that they have, she asks him point blank, did your ex-wife ever see any child pornography? And he says no. And the discussion they have is she says there's a bunch of pictures on the hard drive. You need to clean off the hard drive. This is the ex-wife. There are a bunch of pictures on the hard drive. Can you clean it off? Can you save these to a CD? And he wholesale copies as many pictures as he can fit onto a CD and moves them over to that medium. There's some 23,000 pictures on the CD. Most of them are family vacation, cars, that sort of thing. There's adult pornography on there. Rogers has admitted having an obsession and an interest in adult pornography. And then there are 178 pictures that are alleged to have been child pornography.
Well, there's evidence that the CD was within his personal belongings, is in his closet or...
Correct, Your Honor. I believe
so you do have the CD.
That's correct.
So there's evidence that he knew that he had the CD.
There's evidence that he constructively possessed the CD. It would be a constructive possession case.
Right. Then doesn't he tell his girlfriend that, explain how that stuff could have accidentally gotten on there? So he indicates some awareness that there is child pornography on the CD.
Well, yes and no. I don't know that first of all, I think he never says or admits that there is child pornography on the CD or that he knows it. I think all the evidence is to the contrary. If you read the transcript, he says at 9 of that wire transcript, I didn't even know it was on there. At 26, she asks him, swear to me that you did not know there was child pornography on that disc when you downloaded them. And he says, I swear to you.
Well, what is this where he says, I saw those images just like you did, okay? Whatever you think it is that I've done so wrong, you are just as guilty because I saw those images. The ones that I knew about, I deleted.
Well, correct. He says the ones that I knew about, I deleted, which is another one of the denials where he says, I didn't think any of this was on here. And what he says is he offers an explanation. Look, if this ended up on here, here's what happened. I had an interest in adult pornography. I downloaded thousands of images. And when I searched for these images, every once in a while, something would download, and I didn't know what it was until it downloaded. And then I saw it was that. The ones I knew about, I deleted. I had no idea there was any of that left on there. He even asked her, he says, how many did you see? 1? What are we talking about here? Because his testimony that's unrebutted is, I didn't know that was on there. I thought I deleted it. When she first confronts him with it, her testimony at trial, her live testimony, is I went to him and said, what is this? And he says, I have no idea what you're talking about.
Was there evidence that 20 to 30% of the pornographic images on the CD were in fact child pornography as opposed to adult pornography?
That was the evidence, Your Honor.
And the jury take that into account. If he knows that there's adult pornography and 20 to 30% of the pornographic images are child pornography, can the jury infer that he knew that, when you have that high number, it's not like one slipping in. Can the jury infer that he did have knowledge of child pornography on the CD?
No, Your Honor, because we're here on the sufficiency of the evidence, which is de novo for this court. And the cases that the state cites, particularly the Odom case and the Whale v. State case, recognize that if it's a constructive possession case and there's joint possession of the area where the contraband is found, which here could be the closet, arguably, or the computer that his ex-wife said, I need you to take all of these photos off, you cannot infer knowledge in a constructive possession case where there's joint possession of the premises where the illegal material was found. There has to be some independent knowledge, or independent evidence, of either actual knowledge of the illegal nature or some other statements and circumstances that lead to an inference of guilt. But just because it was found there, you cannot infer knowing possession in a constructive possession case. I don't know the numbers on the disc. It does say 20 to 30% of the pornography was allegedly this child pornography, but there's 23,000 pictures on there. Most of them, I think, were the family pictures. But that certainly shows that it may have come from the family computer, but it doesn't show that he had knowledge that the child pornography was on the family computer, absent something different.
Were there any motions filed below with regard to the sentence? Was the 75-year sentence vis-a-vis a 5-year probation offers kind of significant disparity? It
is, Your Honor. It does sound, a little bit like maybe a vindictive sentence issue, but we argue that when you look at actually what happened here, it's almost a 10-year-old CD. He's convicted to a 75-year sentence where he has to serve 63 years minimum. It's a de facto life sentence. Rogers will almost certainly not survive to see freedom again. It's grossly disproportionate to the crime, especially when we compare it to the fact that in Florida, 88% of all inmates will be released at some point. That for other sexual crimes, the sentences are much less, and that if you look at other jurisdictions, the 900-month sentence given to Mr. Rogers here is disproportionate to those in the other jurisdictions.
Was there any motion filed below addressing the sentence?
There was, Your Honor. There was a majority of the list of cases and the statistics in our motion come from, I believe it's in volume 8 of the record, which is the motion to correct the sentence that was filed below. There's a little bit more there with respect to filing cases from other jurisdictions about the sentencing. There's a little bit more discussion there about the score sheet. And
was there a claim of vindictiveness? Or
I don't believe the vindictiveness was
the only
raised,
argument below that it was disproportionate?
Just that it was disproportionate, constitutionally disproportionate.
Has your client filed a motion to mitigate the sentence yet?
Not yet, I don't believe, Your Honor.
You know you've got time after the mandate to do that, right?
Yes, Your Honor. On the fundamental error case, if I may, since I'm coming up to rebuttal time, the fundamental error in this case exists, and the reason we submit that a judgment of acquittal is appropriate because the state didn't prove the required knowledge, which is mentioned twice in the statute. But alternatively, a new trial is warranted because the conviction was obtained by way of fundamental error. The state played an unredacted tape where Ms. Schlegel was wearing a wire during a conversation with the defendant. That tape itself was hearsay. It was double hearsay. And I would submit that to the extent she's talking about what the therapist said or did.
Well, the tape was admissible. There were relevant aspects of it, right?
I would agree there are relevant aspects, but the problem is that the overwhelming majority of the tape is irrelevant evidence and highly prejudicial evidence.
Well, I mean, if evidence is relevant, it's admissible. That's what the evidence code says, right?
Unless it's highly prejudicial.
Unless its prejudicial effect is substantially overcomes its relevance, right?
Correct. Its probative value is substantially outweighed by.
Is that your argument that 9403 objection should have been made?
Yes, Your Honor, and we acknowledge that an objection wasn't made. Therefore, the standard is fundamental error, and we believe we meet the fundamental error. The probative value is substantially outweighed by the unfair prejudice because, in the first instance, the tape contains a significant number of allegations by Ms. Schlegel that Mr. Rogers was guilty of the conduct for which he was on trial when the tape was played. It also contains a huge number of accusations of his interest in pornography generally, which is irrelevant to the issue of the possession of the child pornography. But the problem with that is that it becomes a feature of the state's case. The state refers in closing to tons of pornography, videotape after videotape. In the closing rebuttal, they say she was throwing out tons of pornography. So it becomes this issue that this gentleman had an interest in adult pornography, therefore he must have also been interested in child pornography. I would also note that it's fundamental error because, well, it contains statements about Shagle's opinion about Rogers' veracity, whether he's telling her the truth. It is mischaracterized. The prejudice comes also because the statement is mischaracterized by the state's witness and the state in opening. In opening argument, the state says, you will hear the defendant in his own words acknowledge that that's his CD. There was no such statement on that recording.
Do you know this, on the disproportionate sentence issue, do you know this Rummel versus Estelle, United States Supreme Court case? Are you familiar with that case?
I'm not familiar with that case.
According to the note here, I don't know whether this came from the brief, it's in the bench memo, but upholding imposition of mandatory life sentence under Texas's recidivist statute, where the defendant's third felony conviction was for stealing obtaining $120 by false pretenses. Have you seen that case at all?
I've not seen that case, Your Honor. I would refer the court to the cases that we cited, and there was some mention in the brief of the Pennsylvania case, which
What's your best case on disproportionate sentence?
I believe it would be the Pennsylvania case, Your Honor, which is the case where they reversed I believe it's a 72-year sentence for possession of 90 images of child pornography.
Was that a Pennsylvania state court case or a U.S. Supreme Court?
State court. State court, Your Honor. I see that I am running up on time. I'd like to save these last 4 minutes for rebuttal. That's okay.
All right.
May it please the court, my name is Chris Davenport, and I represent the state of Florida.
I didn't mislead counsel there on the motion to mitigate, did I? If there's not been a motion to mitigate filed before or during the direct appeal, there is a period of time, I think it's 60 days after the mandate, within which a motion to mitigate can be filed with the trial judge. Is that right?
That's my understanding, yes. So he can still do that. I mean, whether or not that'll be successful, who knows? But he
Well, it
certainly
should be,
could do
shouldn't
that. You know, he was convicted of 125 separate crimes.
Right.
He got 7 months per picture. Is that constitutionally disproportionate? No. Is it a very harsh sentence? Yes. It's up to the discretion of the trial judge.
You can't, I've been doing this a long time, Mr. Davenport, so have you. I mean, it's hard for me to recollect a case that, where the sentence was as harsh compared to the conviction. This guy's never been convicted of a crime before, right? He's a first-time offender, right?
First offender, but he was convicted of 125 crimes.
How old is the appellant?
I think he's 58.
58, so it is tantamount to a life sentence, essentially, for a first offender, and
Well, it's a 75-year sentence. It's not like...
It's tantamount to a life sentence.
Well, he probably will not be able to complete that sentence, yes.
Right. He can't do all the time that the judge is giving him.
He can try his best, but I can't imagine he will complete it all. But again, when you look at what's grossly disproportionate, as the U.S. Supreme Court
Well, the other thing that concerns me about it, although they haven't raised vindictiveness, is the whole idea that the trial judge rejected his attempt to plea, didn't he? Didn't he attempt to plead to probation, and the trial judge wouldn't let him do it because he wouldn't admit guilt?
That does not ring a bell to me. It's
Okay,
certainly possible, because they didn't raise it as an issue.
He rejected a plea pre-beginning of the trial, and
Where he
because
could
he
have
didn't
gotten
want to
probation.
register as a sex offender.
Oh,
And
okay.
had a change of heart either right before jury selection or during it. And the judge said, I won't take a no-load, I'll only take a guilty.
Well,
And the plea offer was 5 year's probation.
What did the
Well,
state
he clearly
learn?
should have done that, but,
what-
you know,
what
he
chose
should
for-
have entered a guilty plea. He took a
recognize,
shot.
you know, I recognize that the state is obviously not bound by its pre-trial offer. But-
Right.
But as it relates to the issue of disproportionate sentencing, what did the state learn at trial that it didn't know pre-trial? That, you know, at pre-trial, the state was happy with 5 years of probation. Post-trial, the state now seems to be pretty pleased with 75 years of prison.
Well, I mean, that's, you know, pre-trial, everybody's going to resolve this. You don't have to go through the time and expense of a trial. You don't have that chance of an acquittal. I mean, you know, they portrayed this
Well, no,
ex-wife as
I'm talking about what did the state know from a factual perspective, not just from a, you know, tactical perspective, but from a factual perspective. You didn't learn anything at the trial that you didn't already know.
I would hope not. I would
really,
think
the
that
only
the state would
thing-
know it all.
Only thing the state gained was, A, avoiding the cost of a trial, which is fairly minimal.
And the
B,
possibility
the
of an acquittal.
possibility of an acquittal.
Right. And,
Let's
you
talk
know,
about
who
the
knows
knowing-
what the victim wanted to, if whether or not, well, the victim, the ex-wife, whether or not she wanted to testify. I mean, she was pretty angry. That could have been a factor in their generous offer before trial as well. I mean,
Well,
we don't know at this level.
I can understand. I mean, basing, you know, having looked at the stuff, she was probably a witness that the state had some question about how
Right.
she would come across at trial.
Right.
Let's talk about the knowing aspect. Apparently, this statute requires, A, that you know that you possess in this case, the disc that had
Yes.
the pictures, and B, that you know that those pictures are child pornography.
Yes.
I don't think there's any question that this was his disc. I mean, he testified
He admitted
that
creating it, yes.
He created it and all that sort of thing. But what evidence was there other than the fact that he admitted creating the disc, and that the testimony was that it was created at one, you know, they just took a whole chunk of pictures and transferred them over?
The disc was created at one time. The
Right.
pictures were downloaded at several different times. The child pornography pictures.
Was there any evidence that would suggest one way or the other that the pictures that were child pornography, were those downloaded individually? Could they tell, for example, if they were downloaded individually, if they were downloaded, if you had to open them to see them, or if they were downloaded without opening, or could you tell?
They could not tell if, you know, how they were downloaded. They could tell what dates, and the child pornography pictures were downloaded on more than one date, so it wasn't just one accidental thing.
Were other
But-
pictures downloaded on the same date? In other
I believe
words,
there were,
What I'm
yes.
trying to understand is this a situation where you go in, you look at a child pornographic picture and download it, or is this a situation where you just select, you know, 100 pictures at random and dump them onto a disk, figuring I'll look at them later?
Well,
Or did the evidence
I think
reveal
we
that
don't-
one way or the other?
the evidence did not reveal it. It could have been either way. I mean, there was massive amounts of pornography that was legal, downloaded on the same dates as the child pornography. But here's how we know that he knew that he was picking up child pornography. He said to the ex-wife, yeah, well, every now and then I'd get them, and I thought I got rid of them all. But clearly he had kept 178 pictures. So the jury didn't have to believe that he was intended to delete them all. He sure ended up with 20 to 30% of his pornography was child pornography. The day before he made this disc, which he told his ex-wife that he transferred all of his porn onto a disc from his computer. The day before he had downloaded a video of a young child having sex. It was a video the day before. He chose to move that all over. The jury could have believed him that he didn't know it was there and he thought he had deleted it all. They clearly did not.
The day before he had the confrontation with his wife, or the day before what?
The day before he moved everything from that he created the disc. This stuff had been downloaded onto a computer and he created the CD.
Did the evidence reveal whether or not the photographs or videos had been viewed?
We know at least some of them had been changed to the extent that he created thumbnails out of some of the pictures. And according to the detective, now, I didn't really understand this, but according to the detective, to create a thumbnail, you have to have affirmatively opened that picture and done something to it. That was the testimony at trial. So we know he had actually gone in and viewed them. He told on the tape, he says, yeah, I knew I had those. I saw them now and then. I accidentally downloaded them. If I accidentally pick a marijuana plant when I'm picking dandelions in a field and I see that it's there, I have an affirmative obligation to get rid of that, not put it in my stuff and bring it down to Florida. You know, he knew it was there. He admitted on this tape that he sought out pictures of teenage girls. Now, he said they were 17. 17 is still child pornography, as that's defined by the statute. He was seeking out girls that were underage. So he sought out those pictures. He had 178 pictures. 20 to 30% of his pornography was child pornography. It had happened on more than one date. You put that all together, and we submit the jury could believe that testimony and find that he knowingly possessed it.
Let me ask you about the sentence issue. Judge Orfinger asked you what the state learned. What did the judge learn?
Well, the judge,
between the time that he rejected the plea and the time of sentencing.
The judge learned how all of the details, how it got down here. He heard his statement to his wife that he was seeking out these pictures.
Was the sentence immediately after the verdict, or was it postponed until?
I know there was a PSI, so I would imagine that it was postponed. He saw all these pictures. The judge hadn't seen them before trial, I wouldn't think. So, again, it seems like a very harsh sentence for a first offense until you consider it was 125 counts. It wasn't, he compares it to one count of sexual battery on a child, which is a horrible crime. One count. If you do that 125 times, you're going to get a much harsher sentence than this. When you look at the number of counts, 75 years, is it grossly disproportionate, which is what the test is, and we would submit it's not. It's a harsh sentence. Child pornography is a horrible crime. The legislature has decided that each image is its own offense. He did it a bunch of times. In the cases I cited in my brief, courts reviewing proportionality say, you have to look at the count, each count separately. Otherwise, you can create an Eighth Amendment claim by repeating the same crime over and over, because you're going to get a harsher sentence. It's 125 counts. 7 months a picture is not grossly disproportionate, and we would ask the court to affirm. Thank you.
Thank you. Your Honor, if I may, I'd like to start by referring to just one of the issues that I wanted to bring up before, but I didn't, that I think is somewhat implicated by the argument from the state, and that's that in these other constructive possession cases, there generally is more evidence of manipulation. In the Strauss case we cite, they can tell that when the gentleman went in there and downloaded it and how he manipulated the pictures on the computer itself. The same thing is true for, I believe, the Bustle case, which is the one where the boat captain was out taking pornography when he goes offshore on a boat, and there was evidence that he was home on the days it was downloaded. We don't have that here. We have the one CD that was created in 2001.
What about the detective's testimony regarding the thumbnail?
To the extent there are changes for the thumbnails that occurred at some unspecified time before it was created, the problem with that goes back to what I referenced in my opening argument, and that's that it's a joint possession issue. The computer and where these images were stored was in the joint possession of the defendant and his wife. So there's no way to know, and there's no other evidence to show that it was him that made those changes rather than someone else who may have had access to that computer before the CD was created. And there's a case on point out of the Fifth Circuit, which is U.S. v. Moreland, and that's essentially what happened. It's a computer shared by a gentleman. The site for that is 665 Federal 3rd 137. A gentleman that shares a house computer, actually two computers, with his dying father.
So is your argument that there is evidence that child pornography was seen and modified, but that the jury couldn't tell who had done it between the girlfriend and the defendant?
Yes, Your Honor, that in a constructive possession case, there must be more than just the inference that because it was found there, it must have been the defendant who did it.
Could they tell, was there any testimony as to when those manipulations, the creation of the thumbnail had been done? In other words, was it done at the time of downloading, at the time that the CD was burned, before the CD was burned, or is there any evidence that it was looked at in the 10 years intervening and perhaps created then, or was there any testimony?
I don't believe there's any testimony or evidence. I certainly don't think there's any way they would be able to tell whether it was viewed from the CD within the 10 years between trial or whatever. It's a little less than 10 years, but...
Why is this a constructive possession case? Explain that.
Because it was not found in his possession. It was the
Was
evidence...
not found in his actual possession?
Correct, Your Honor. It was found
Wasn't there direct evidence that it was his?
It was found within his dominion and control. It was found in his closet.
But your argument on constructive possession really goes to the fact that although he admitted to creating the CD that had the images on there, his argument is that I just downloaded these wholesale and other people had access to the computer. They might have put this on there and I then just dumped it over unknowingly.
Correct. Our argument is...
constructive possession of the original computer that you're arguing about.
Well, I'm not... It would be disingenuous to say if he knew they were on the computer and then transferred them to a CD and said, well, I didn't know what was on that CD, he would get a pass. That's not what the law would say. But if they don't establish that he had knowledge of it at some point on the computer or otherwise transferred to the CD, they haven't established the knowledge.
Well, if the evidence was two people had access to the material that was the subject of the modification, if you would, can the jury find, well, we conclude from the evidence that there's no way it was the girlfriend, and if there's only two people that had access to it, therefore it must be the other one?
Not based on just inference, Your Honor. The Odom case and the Whale case say the
recorded conversation, she indicated that, she didn't become aware of it until, she took the CD out of his room.
I'm speaking to the ex-wife, not the girlfriend, not Ms.
Okay,
Shagle, who
okay.
ultimately made the
Right.
conversation.
Okay.
And that if it's constructive possession, the Whale case says the knowledge of the contraband cannot be inferred but must be established by independent proof. There must be some evidence showing actual knowledge or incriminating statements and circumstances other than the mere location of the contraband, which is what happened in this case. Thank you.
All right, thank you both. We'll call the next case now, Lawrence Pino versus